trial proceedings in civil litigation. In other words, what we are looking at is Order 30, Order 31, and Order 32 of the Abia Set of Nigeria Practice and Procedure Rules 2021. But I'm just going to do the much I can to tell us what a trial proper is. Now we'll take it from the point of report. Report of what? Now, when the judge comes out with the pre-trial report, it means that the stage is set for the trial proper. Right. And the trial proper, we will be looking at Order 30. Some of the things we need to know here is that non-appearance of both parties. What happens if both parties on the day slated for the case, both of them didn't appear? Mind it has already been scheduled that case will hold that day and hearing will commence on that day. What if on that day none of them appeared, they were all absent? What will happen? Order 31 says when a cause on the cause list has been called for hearing and neither party appears, the judge shall, unless he sees good reason to the contrary, strike out the case. So when parties fail to come to court, the general rule is that the court will do what? Strike out the case. But the court has a discretion. The court has a discretion to seek for reason why the matter should not be struck out. The court may simply say, this case is coming up for the first time. It may be the parties have forgotten, and my lord may ask the clerk of court, call the bailiff, find out if my report has been served on the parties. And then when that is done, if my lord is minded to adjourn the case, my lord will also make an order for what? Hearing notice. My lord will make an order for it because two of them weren't in court. My lord will make an order for hearing notice to issue so that the parties will now know when the matter will be coming up next. And then another issue is when the claimant is present but the defendant is absent, what will happen? The court may allow the claimant to prove his case. You know, the court is like a train. It doesn't wait for the passenger. It's the passenger that goes to the station to wait for the train. So if the claimant is present and the defendant is absent, my lord can ask the claimant to go ahead and prove his case. That is, in the absence of any letter for adjournment. In the absence of any letter for adjournment. But if the defendant had written a letter seeking for adjournment, if the defendant had written a letter seeking for an adjournment, the trial judge will consider the reason. The trial judge will consider the reason for the adjournment sought for. And if satisfied that the reason is tangible, the court may go ahead and adjourn the case, either with terms or without terms. Either with terms or without terms. You know what that means? The court may ask him to pay cost, at least for wasting the time of the court for that very day. If the defendant is present and the claimant is absent, the defendant may apply that the case be dismissed or struck out. The defendant may apply that the case be dismissed or struck out. If he has any counterclaim, he may be allowed to prove his counterclaim. He may be allowed to prove his counterclaim. Any judgment obtained by absence of a party is called a default judgment. Any judgment obtained at the absence of a party is a default judgment and can be set aside within 7 days of that judgment. Within 7 days of the delivery of that judgment, or such other time as the court may enlarge, or such other time that the court may enlarge. When the matter is set to go into trial, the trial judge shall determine the party on whom the onus of proof lies. The trial court shall determine the party on whom the onus of proof lies. You still remember what we learned in your law of evidence?
Yes, sir.
That party who will lose if no evidence is adduced by that party is the party who has the what? The onus of proof. In other words, not every time that the claimant will be the one to win his case. So my lord will determine who has the onus to prove, and the person who has the onus to prove will first of all do what? Start calling his witnesses. At the hearing, no oral evidence is permitted. At the hearing, no oral evidence is permitted except adoption of written statement on oath. No oral evidence is allowed. But the only oral evidence you allow is that when the witness mounts the witness box, he is asked his name. What is your name? He states. Your address, he tells the court. Your occupation. The idea is to sort out his own written statement on oath and to make sure that he's the one who wrote it. And then you ask him, you find your written statement on oath. If you want to be smart, you add in this court registry on so day. And he said yes. I will tell you why I use that. And then after he has said yes, you ask him, do you wish to adopt it as your evidence in this matter? He said yes. Even if the written statement on oath is 100 pages, he has finished talking. He just adopt and do what? Tender. So once the written statement on oath is adopted, the next thing is whether he has documents to tender, documentary evidence, whether he has documentary evidence to tender. The counsel leading the witness shall identify the documents to be tendered and the paragraph in which those documents have been mentioned. So what it entails is that, assuming I'm leading him, after he has adopted, I say, yes, witness, at paragraph 7, you said that you have a power of attorney to tender. He said, yes. I'll bring it. Is it the power of attorney? He identifies it. I say, this is it. I say, my lord, I apply to tender the document as is-based. I'll wait. My lord records me. Ask the other lawyer, any objection? The other lawyer, because it is pleaded, it is relevant, he may say there is no objection. That's what I'll be doing. Taking him to the paragraph, identifying the document until I'm done with him in respect of every document he has wanted to tender. So after I'm done with him, then the opponent, and then there is something that is important. By rules of court, when you tender a document, an SB, that SB should be read, right? But you discover that most courts don't observe that. But it's safer to say, my lord, immediately my lord said, if it's A, he said, my lord, I apply that the document be taken as read. And my lord said, okay, no problem, you move ahead. Because by law, my lord is supposed to read it. And to read it means wasting further time. And reading it is of no consequence, of no importance to anybody. Since my lord, in the end of the matter, will go home and read it. Right, but to satisfy that legal requirement, you can simply do what? Make that application. And then the next one is, if for instance you have a witness on subpoena, If there's a witness on subpoena, such a witness must be so identified and the subpoena tendered through the witness. The witness tenders the subpoena as well as his written statement on oath if he's going to testify or if he's producing a document. He simply does what? Tenders the document. That means he was served with subpoena duces ad tecum. But subpoena duces ad testificandum means that he's going to talk. Right, so they are two different things. After the witness has tendered all his document, he will be cross-examined by the opposing lawyer or lawyer to the opposing party. Will cross-examine him. At the end of cross-examination, if there is any ambiguity resulting from the answer of the witness while being cross-examined, the leading counsel will have a right to re-examine him. This is another difficult aspect of the law. Most of the time, some lawyers don't know when to re-examine. You must make sure that his answer is ambiguous. If, for instance, he was asked a question and he said yes, and it is such a question that yes can be answered, no can be answered. Do you understand? You can now, first of all, before asking, say, my Lord, so question is ambiguous in that it pertains to answers, but you don't have to answer it yourself. You don't put the answer to the witness, that would be misconduct, right? So, if my Lord allows you, you now ask the question, when you said yes, did you mean you now put it to him? And he will say, yeah, that was what I meant. Because some no can mean yes, some yes can mean no, depending on the question and the answer so put. An SB tendered can be released and substituted with a photocopy. An SB, you know, when you tender an original document, assuming somebody has defamed your character, saying that you wasted your years in Abia University, you are not a lawyer, and you have sued for defamation of character, and you have tendered your certificate, both your LLB and the one of call to bar, you have tendered the original. So you don't allow my Lord to mark on it. Your lawyer quickly makes an application, my Lord, I apply to substitute the original with the photocopy. After examination, my Lord will say, okay. So they will, my Lord asks you, you have a photocopy? He said, okay, clerk of court, examine two documents. If they are the same, mark the SB on the photocopy and return the original. So this is part of the trial procedure. So this procedure goes on until all witnesses are taken. So I will jump order 31 and go to order 32 for us to pinpoint some certain things that are necessary during trial. As a counsel in a matter, you must be able to know when a fact has been admitted. Don't cross-examine on a fact that is already admitted. If not, you're giving the person a second chance to do what? Contradict himself and maybe spoil your case. Are you following me? If somebody has already made an admission, leave that one. Don't cross-examine. And don't even cross-examine based on your strongest point. No. If you cross-examine based on your strong point, that person will deny and you'll be struggling to extricate yourself from the problem. So those are the evidential things we need to know. And then when you are calling an expert witness, make sure that you establish the competence and qualification of the expert. Establish the competence, qualification of the expert, and his history, his practice history. So it's just like you bring a new fact. The person just graduated. He had just been called to bar, and you bring him as an expert. I'm a lawyer. You understand? I said, my friend, how long have you been practicing law? And he said, I was called last 3 weeks. So look for that expert who is seasoned, All right. And then when you're tendering a document, make sure you agree on tendering documents that are admissible in law. All the rules guiding documentary evidence must guide you. Primary document, secondary document, public document, private document, get to know the rules. When you have served a notice to produce and they have not produced it, you need what? Secondary evidence. When you want to rely on computer-generated evidence, your mind should be telling you section what? 84 of the Evidence Act. Make sure that you establish all those conditions for whatever they are worth. So those are the things that will guide you. And in cross-examination, make sure you don't ask questions that are scandalous. Go straight to the point. Attack the issue, not extraneous issues. Right. Don't begin to attack somebody's personality if it's not an issue, if it's not relevant. So it will not help your case. It will simply show you as somebody maybe who doesn't know, somebody who doesn't know what he's doing. When all parties are testified, that's both parties are testified, the trial court will order for final written addresses. Final written addresses. Every address must be paginated. So they adopted this rule from the Court of Appeal rules. Every final written address must be paginated and must not exceed 35 pages. It must not exceed 35 pages. It must be done on A4 paper. They will tell you to use other Times New Roman or Tahoma. And the font will be font for pin. The size of the font is for pin. And in your written address, you can structure it in such a way that the first portion, in after your heading normally, the first portion will introduce the matter that the claimant took out a case against the defendant for. You repeat the orders of relief that he is seeking. And in response, the defendant filed a 32-paragraph statement of defense, after which the claimant again filed a 17-paragraph reply. In the course of the proceedings, the claimant filed amended, just like that, you just tell the story. Pre-trial commenced on so-so day and ended on so-so day. Right. At the end of the trial, ended, you give the date the trial has ended. The next one, you move to evaluation of witnesses. You pick the case of the claimant, the witness for what he said. Are there contradictions? Try to bring them out in summary. And then maybe you're writing for the defendant. In your defense, you're praising your own witnesses. They were cross-examined, they were shaking, they remained firm in their statement, but the claimant witness number 1 contradicted number 3, contradicted number 4, so it cannot be said that they have achieved and that they contributed anything positive to the case of the claimant. Then after that, you count your issues for determination. After counting your issue for determination, you go over to do what? Legal argument. On your legal argument, you now look at the relief sought. Relief 1, has he proven it? You make your own argument based on the facts and evaluated evidence of witnesses. So when addresses are concluded and exchanged, on the day of adoption, there will be an oral adumbration. And my Lord may ask party to adumbrate for 5 minutes. Or ask party not to adumbrate at all, just adopt. And my Lord will give date for judgment. Now, constitutionally, a judgment must be given not less than 90 days from the day the matter is concluded. And further down in the provision of the Constitution, is the provision that says that non-compliance will not invalidate the trial except it is proven that there is what? Miscarriage of justice. I don't know whether I pointed this out before. In the former law, there was no such provision. So when judgment exceeded 90 days, because at times these judges are human beings, they fall sick, they have their own needs, they may not be able to give the judgment within 90 days. So that's why we have a modification of the law. So that when judgment is not given within the stipulated period of time, the question will be, this person who is complaining, has he suffered any miscarriage of justice? If the answer is no, it will not invalidate it. But if the answer is yes, maybe in such a way that due to the delay, my Lord forgot what happened.